we were just discussing the general principles of contract. And today we are going to refer section 11 of Indian Contract Act. So that's an important section as far as our Indian Contract Act is concerned. Section 11, that is competency or capacity of the parties for entering into a contract. So we have already discussed what are the main essentials for entering into a valid contract. So when the parties are entering into a contract, the parties, they should be competent. What are the factors that make the persons competent, or what are the capacities of the parties for entering into a contract? As we all know, the parties, they should attain the age of majority. Second, both the parties who are entering into a contract should be of sound mind. And third, they should not be disqualified from contracting by any law to which he is subject to. So there should not be any sort of disqualification from entering into contract by any law to which he is subject to. So these are the three elements. These are the three factors whereby the parties, you can say that they are competent for entering into a contract. So, as we all know, a minor, whether he is entitled, whether he is having any competency for entering into an agreement. That is, the person should attain the age of majority to which the law or the law which he is subject to. As we all know, the age of majority is 18 years. Usually in many books it is used to say that minor's contract is void ab initio. No, it's not correct. Because minor is not competent to enter into a contract. Minor's agreement, we can only say minor's agreement, as minor's agreement cannot be, it's not enforceable. So it is not a contract at all. So whenever we are just stating the matter, we could say that it's not the minor's contract because there's no contract with respect to a minor. It's only minor's agreement because it's not enforceable by law. So minor's agreement is void ab initio. Void ab initio, that means void at the very beginning. Whenever you are just entering into an agreement with the minor, initially, at the very beginning, you can say that it is void. It's void ab initio. There are some contracts where initially when we are entering into a contract, that may be valid. But subsequently, it became void, maybe due to the changed circumstance or due to some impossibility. The very best example I could say that when a person has offered to paint a picture, and by the time he met with an accident and he is not able to draw. So initially that particular contract was valid and subsequently it became impossible. So such contracts, you can say that's a void contract. But with respect to a minor, you cannot say that the minor's contract is only a minor's agreement because it's not at all enforceable by law, because it is void ab initio, that is void at the very beginning. And as we all know, there is a landmark decision, this Mohori Bibi versus Dharmadas Ghosh. As you all know. Let us see the facts of the case. In that case, Mohori Bibi versus Dharmadas Ghosh, what happened is, Dharmadas Ghosh, he was a minor. He mortgaged a property. And for what? For getting some amount. And who was that money lender? His name was Brahmodhat. So what he did is, Dharmadas Ghosh, he was a minor and he mortgaged a property, and for getting some amount, and the money lender was Brahmodhat. While in appearance, you can see, whenever we see, as per the appearance wise, he looks like a major. He's having some maturity. But they could have verified the documents. They have not verified it. They should have asserted whether he's a minor or not. And later on, what happened is this Dharmadas Ghosh, actually his mother, has filed a case to set aside the mortgage. Because that mortgage or the amount payment, it doesn't have any sort of contractual validity because it's not a contract at all. Because it was entered with a minor, that minor's agreement is void ab initio. So by the time what happened is the Brahmodat died. And the case was actually continued through his legal representative, that is Mohori Bibi. So Mohori Bibi is the wife of the moneylender Brahmodat. So what was the decision? He is not entitled to give back the amount because that particular agreement doesn't have any sort of validity. That is, minor's agreement is void ab initio. And the mortgage, it was set aside, and he was not entitled to pay the amount even to the wife of Brahmodat. So that was the case. So it's an important decision where it was said that the minor's agreement is void ab initio. And in another instance, there may be some questions. We could say that whether on the attainment of majority, whether that particular agreement can be ratified. That's a question which would come into that's actually those questions can be just asked. On attainment of the majority, when an agreement is entered at the time of minority, or when the person was minor, whether that can be ratified. No. That cannot be ratified because while entering into that agreement, that at the very side, it is void. So that cannot be ratified. Whether a minor can be a partner. Minor can be a partner. No. Minor cannot be a partner, but he is entitled to enjoy the benefits of that partnership. He can share the profits, but he is not liable for any sort of loss. Whether minor can be an agent, he can be an agent, but he doesn't have any sort of personal liability. Suppose a joint agreement is entered between a major and minor, they jointly enter. You can enforce the contract with respect to the major, but minor's agreement, it is void. So these are the instances with respect to the. So it's very clear. You cannot say that minor is called as minor's agreement and that agreement is void ab initio. That the important cases, of course, Mohori Bibi versus Dharmadas Ghosh. The mortgage was set aside and he need not repay the amount to that moneylender's wife because that particular agreement itself was void ab initio. So this is with respect to this, what you call the competency of the parties, mainly the attainment of a majority. The second point is the persons entering into a contract, they should be of soundness of, they should have the soundness of it. So what makes a person sound? What do you mean by the soundness of mind? Soundness of mind means the person should, while just reading the terms of the contract, you should understand. The person should understand the terms of the contract, the terms of the agreement. And also, the thing is, whenever he's entering into an agreement, he should understand the terms of the contract, the terms of the agreement. And also, they should form a rational judgment to the effect upon his interest. So while reading the terms of the contract, you should have that soundness of mind. The soundness of mind for what? To forming a rational judgment to the effect upon his interest. That is soundness of mind. So there are some instances where a person may be lunatic. He may be in his lunatic asylum. He may not be able to understand the terms or the nature of the contract. He may not be able to form a rational judgment to the effect upon his interest. But still, there are some time where they could say that is lucid intervals of time. The lucid intervals of time, he is able to understand the terms of the contract. is able to understand or he is able to form a rational judgment to the effect upon his interest. At that particular intervals of time, this person can enter into contract. So that at that time he is not incompetent, he is competent. That is lucid intervals of time. Some instances you could say we are all normal. But there are some time where we could say that we may also be abnormal. In that abnormal time, we may not be able to understand the terms of the contract. We cannot enter at that particular time. There are some instances where a person is having a very high temperature, delirious fever. He cannot read some agreements. He cannot understand anything. At that time, whether he can enter into contract? No, he is incompetent. At the time when a person is in the, he's a drunkard, or when he is in that particular, he is having the drunkardness, or he's not able to understand the nature of the contract, and he cannot form any rational judgment while just reading this particular contract, cannot understand anything. At that particular moment of that drunkardness time, he is not competent to enter into contract because he is under the influence of that drunk or drinks. So if a person is under the influence of some drinks or is a drunkard or he's not able to understand the nature of the contract, he's incompetent at that particular time. But when he comes to his normal life, when he can enter at that particular time where he is able to understand the terms or the nature of the contract or to form a rational judgment, at that particular time, he can enter into contract. So that is with respect to the soundness of mind. And next is, the person should not be disqualified from entering into contract by any law for the time being enforced. The important examples: an alien enemy is disqualified for entering into contract. A convicted person while he's continuing the sentence. And if a person is adjudged as an insolvent, he cannot enter into the contract at the time of his insolvency, because the entire property may be under the revenue departments. So he can enter into contract when he is discharged or where his insolvency has been over. When he is in discharged insolvent, he became solvent. And when a person is solvent, then he can enter into contract. So these are the disqualifications. Okay, so the disqualifications, one is an alien enemy, a convicted person, when he's continuing the sentence, and the next is if a person is adjudged as insolvent and he cannot enter into contract, but he can enter into contract when solvency or insolvency is discharged or he later becomes solvent. So this is with regard to section 11. So what makes a person competent, or what are the capacities of the parties for entering into contract? The person should be major, he should be having a soundness of mind, that is, he should understand the terms and nature of the contract and to form a rational judgment to the effect upon his interest. And third is, he should not be disqualified from entering into contract by any law for which he is subject to. So these are the capacities of the parties, and if these all features are there, he can enter into contract. Now, next is as with regard to the consent. We have just discussed some of the elements, likewise, what is this free consent? So, a consent is said to be free. So, whenever the parties are entering into a contract, there should be free consent. The consent should be free. So, what makes a person entering into contract? He should consent to it. As we all know, there should be, we have discussed, there is a union of minds, consciences, and idem. There should be identity of minds. So, with respect to that, a consent is said to be free when it is not caused by coercion, when it is not caused by undue influence, when it is not caused by fraud or misrepresentation or mistake. If these factors are there, then said that it is not a free consent. So consent is free. It should not be caused by any sort of compulsion, pressure. It should be genuine. It should be out of a free will. So suppose a person is forcing me to enter into contract and I've entered into a contract. What is the effect of such contract? That is very important. It's very important because especially in Munsiff magistrate exams, all these portions usually they used to ask in this particular area regarding the validity or the after effect of this sort of coercion or anti-influence or fraud or misrepresentation or mistake. All these the questions you actually they're repeated questions.